What does it mean to address a human, an animal, a tree, or a plant as comrade? For the Court for Intergenerational Climate Crimes, comradeship is a recognition of the relation between those on the same side of a struggle, a relation that is shaped by common work, common dependencies, and common care. When a river brings life-sustaining water to people, plants, and animals, is the river not working with all humans and non-humans in comradely ways? When a forest gives life-saving medicinal plants, when it provides home to the snake and the mongoose alike, and holds back rainwater from flooding, does the forest not work with all in comradely ways? To harm Comrade River, then, or Comrade Forest, means to harm the livelihood of all comrades, humans, animals, plants, fungi, protists, and monorans, that live in interdependency with that river or forest, or with each other living by that river or forest. Not only those that exist in the present are harmed, but the unborn comrades of the future that are violently forced to live without river or forest. Comradeship is not given. Comradeship is a possibility that manifests through shared struggles by recognizing one another as fellow ecosystem workers. To use the noun comrade affirms a fundamental reality of collectivity, interdependency, and intergenerationality. It affirms that across space and time, we must stand on the same side of the existential struggle between the death form of racial ecocidal capitalism and the living worlds needed for meaningful common survival. Comradeship is an affirmation of collective life in the face of extinction. What's wrong with rights? At least since the European Renaissance and the Reformation, European merchants, a section of the aristocracy and intellectuals, rallied together to bring about a social and intellectual revolution. They changed the concept of rights from an idea in moral philosophy in ancient Europe to a mercantile idea based on property and contracts. This new regime of rights was essential in the colonial period to turn land and living beings into commodities. This caused the first wave of mass extinctions, the extinctions of animal and plant life, and of the human languages and cultures that thrived with them. Here, the death form of racial ecocidal capitalism manifests as the propagation of racial superiority legitimized as the right to dispossess living worlds. The proprietary idea of rights is necessary to enter into contracts. It has become so entrenched in our psyche and our modes of being in the world that we can no longer imagine a world without this foundation. From water, forests, and land, from mineral to fossil memory, from labor to care and love, the proprietary conception of the world rules supreme. It does not matter whether rights-bearing parties appear in the form of the state or private individuals or corporations or NGOs or even rivers and mountains. Modern rights have transformed the merchant's worldview into the human worldview, a merchant's destiny into life's destiny. A rights-bearing river means that the law and not the river will decide how much water humans, birds, trees, and mangroves must get. The relationship between the river and the lives that depend on it are no longer negotiated amongst themselves on the basis of interdependent needs, but instead are mediated by law and contractual obligations. The Court for Intergenerational Climate Crimes recognizes nature as a relation that connects us to human and non-human ancestors of the past, to comrades in the present, and to future descendants. It is those interdependent and intergenerational relationships that bind us together in our common struggle for a biosphere for all. We insist that land, water, forests can never be private property. We demand a new paradigm of climate justice that dismantles the idea of rights from property and contracts and anchors it instead to interdependent and intergenerational relationships between all living beings. We put the law on trial. We charge the law for establishing corporations and states. We charge the law for creating legal personhood for corporations and treating legal persons as if they were living beings. We charge the law for fraudulently claiming that transnational corporations like Airbus, ING, and Unilever are persons comparable to human beings. We charge the law with permitting and encouraging murder of non-human life by limiting the crime of murder to human species alone. We charge the law with deceitful conduct by endowing transnational corporations with human rights, including rights to free speech and conscience. We charge the law with forcibly dismembering nature from people. We charge the law for fraudulently representing ecosystems as property and people as labor force, and for allowing both to be bought and sold in markets around the world. We charge the law for establishing a social order founded on legal entities that can only survive by perpetually extracting life from the living worlds of peoples, cultures, rivers, mountains, forests, seas, animals, plants, minerals, fossils. We charge the law for the massacre of pasts, presents, and deep futures by enabling the legalization of intergenerational climate crimes perpetuated by transnational corporations and states. We charge the law for co-constituting the death form of racial ecocidal capitalism. This is the Court for Intergenerational Climate Crimes. This is the court where pasts, presents, and futures assemble. This is the court of human and non-human and other than human comradeship. Outside the court, non-human comrades are declared extinct plants and animals. Inside this court, they assemble as martyrs of the crimes perpetuated by states and transnational corporations. They are our ancestors who sit by our sides, comrades with whom we hold hands, pause, leaves, as we charge the corporations and states responsible for the destruction of their worlds and ours. Fossils are present amongst us. For millions of years, our ancestors, animals and plants, lay buried in the recesses of time, until modern states and corporations violently excavated and extracted them to burn our futures. This violence leaves generations of animals, plants, fungi, protists, and monorans without resting sites and without life-sustaining inheritances from their ancestors. Humans too assemble at the court. They gather to testify against corporations and states, against ecocidal and racialized crimes committed over multiple generations, against the death form of racial ecocidal capitalism. The humans join their comrades as judges, prosecutors, witnesses, and jury to deliver justice to corporations and states for their intergenerational climate crimes, for numerous extinction wars against all species and against time itself. We future ancestors, we accuse, we bring evidence of what has been done and what is to be done. For that is the burning question of our movement in a burning world. We testify to violated pasts, presents, and futures, and we testify to defiant pasts, presents, and futures. We bring evidence of dying worlds and of possible worlds. We testify not only to the violence that has been done to us, we bring evidence of the living worlds, the life forms, the forms of life that could be, that must be, that were and will be. In the presence of all human and non-human comrades gathered at the Court for Intergenerational Climate Crimes, we proclaim living worlds, interdependent rights, intergenerational solidarity. We proclaim that regeneration of all life forms is the first principle of a law that constitutes shared comradely ecosystems and must be respected unconditionally to ensure deep futures for all, intergenerational, interdependent, regenerational. So that's the CICC project that is still on. The exhibition is still on in Amsterdam and will be there until 16th of January. No, I think it's extended by 1 month, so it goes on till 16th of February. And the space in between the hearings is used by social movements, by people who want to use the space for various activities. So it's a very active space, and that's what we wanted it to be like. You've seen the film, and I won't talk about the CICC. Instead, what I will talk about is the theme for this symposium, which is about language and how we speak about language. And I will just frame my thoughts today. Hopefully we can have a discussion later. So I'll frame my thoughts around 3 strands of thought, if you like. One is, I will try to address issues at 3 levels of reality. The first being the empirical reality, the reality that is the CICC, what we did, how we did, etc. The structural, social, historical, that one. And the ontological. And I think that that thread between these 3 levels of reality is important because liberalism lops off, cuts out the ontological. So we end up all the time talking about facts and about information and about more facts and completely lose our way, and we can't get to questions, the larger questions about who are we, what is the purpose of life, why are we here, what are we doing? Because for liberalism, as you heard, the merchant's view of life, These things are useless questions. They don't bring money. You can't sell them in stock markets. So I think that is one framing that is important. The second one is this question of, I think the Cove Park, the blurb that you put out on the website talked about Western tradition. And we can talk about Eastern traditions. But you can see that straight away we get into language problems. If you call, those people out there, wherever, Africa, Asia, Latin America, how do we describe them? And these people here, how do we talk about them? And again, and I'll come to liberalism, has no fixed meanings for words. And so this can change, it's very fluid. For example, we are now the global South, but 2 decades ago, we were the third world, and you were the first world. I'm using this you and we quite deliberately, but not in an adversarial way. That's how we speak. That's the world we live in. And before that, we were the underdeveloped, the backward, And before that, we were, the inferior races, the uncivilized, so on. This has gone on for a long time. But there is a language that allows this transformation in the language without really changing the relationships. Because the relationships still, the sweatshops are still in India and Indonesia. The consumption still happens here. So there is this language. And I think that it's important, therefore, to kind of ask ourselves, what is this language and what is it about it that allows a change in language, a linguistic change, to act as if it is real change in the world. In other words, that leads us to believe that by changing language, we can change reality. And that is the second framing thoughts. And then the third one is, of course, this comes from a deeply, as we have talked about, Western, Eastern tradition, that everything comes from somewhere. The Maori have a beautiful metaphor for it, that the river of life and the boat on which we use to navigate the river, it comes from somewhere. It has brought us to where we are, and it takes us somewhere. And therefore, when we talk about anything, whether we talk about language, whether we talk about North-South, whether we talk about whatever it is we talk about, the importance of asking, where has this come from? How come it has brought us to where we are today? And where is it taking us? And that trajectory. So these are the 3 framing sort of ideas that I want to use to talk about language, law, and liberalism, which is the theme. One of the important things that I finished this North-South, global, third world, first world thing first. One of the things that, if we ask ourselves, where has this come from? Why have we changed the word but not the reality? And where is that taking us? If you follow that trajectory, then with every change in the language, you will find that it is correlated to changes in capitalism, in the market economies. So before the Soviet Union collapsed, we were third world because the Soviet Union was the second world. And of course, this was the first world. After the Soviet Union collapsed, we became the global South. Because now the world was just 2. There was the North and the South. And it's a metaphor because there is no literal North and South. There is no geographical thing. But the geographical language gives you an idea of somehow, because after all, the world does have a North and a South. So there it naturalizes what is actually human expropriation and exploitation in so many words. I mean, whether we talk about exploitation in the sense of human exploitation, labor, sweatshops, those kind of things, your Gap clothes and H&M and all of those things in everyday life, or whether you talk about it as environment, location of polluting industries. And what we are now seeing in the COP conversations, for example, all this question of standards and setting standards, and ultimately we know that the burden is going to fall on the global south because of the way it is structured, and we continue to believe that changing language will change everything. So that's that. But I want to also go to some very fundamental kind of linguistic problems that we have that I associate with liberalism. We can't conflate Western with liberalism. Because if you look at a lot of the language problems that we have come with modernity, or what I prefer to call European modernity, because there was a Europe before it became modern. But we tend to forget that Europe, what it was like, because we have completely internalized European modernity. And a lot of our problems, if we come to that, is very specific to European modernity, which is what the film talks about, the coming together of the Renaissance, from the Renaissance, the Reformation to the Counter-Reformation. There is a change in the structure of thinking. And it is that structure of thinking, not necessarily essentially European or anything, but it is essentially the modernist architecture of thought that is really challenging. And I'll just focus on three concepts which are very central to as example. One is the nature-culture divide, right? It is impossible today to have an environmental conversation without in some way making assumptions about what we mean by nature and what we do not mean by nature. And suddenly it has become a very complicated word to use. And for us in the CICC, when we were working on this, and one of the things, and this is just as an example, but in many other ways, like, can we use the word nature? Oh, but that is reduction. That is kind of, talking about this deep environmentalism or whatever. But didn't we say that we don't want to make the separation between human and non-human lives? So, why are we talking about nature? But when we were talking in the global south to all our partners and so on, and indeed these conversations have been very productive with Jonas and I, because Jonas comes from, this so-called Western tradition, and I come from a very deeply Eastern tradition, if you like that. So for us, it has been an absolutely enriching experience about, getting to this language thing. The nature-culture divide does not exist in 2/3 of the world. Every witness who spoke at the CICC never made that distinction. And so we need to ask ourselves, where does this come from? Is it something inherently European? Or is it, as I said, something to do with European modernity, or what is called broadly the European Enlightenment? And when we start asking those questions, we find that the nature-culture divide comes with European modernity, because pre-modern Europe was land-based society, social order. Not that there was no exploitation. I'm not idealizing the past, and one should not, do that. But whatever the problems with the serfs and the, peasants or whatever, but they were still close to nature. They were not separated from nature. What European modernity does is the shift from a land-based economy to a commodity-based centered society. And commodities need to circulate. Commodities can't work if there are fixed meanings, if there are transcendental sources of ethics, everything needs to constantly change. And that is why it allows a way of speaking about this. So the first divisions that come in European society is the nature-culture divide. And the nature-culture divide turns nature into property and people into labor force. So you have a land market that allows you have a whole department, a government with surveyors and titling, and all of those are legal reforms. And law is absolutely central in reconstituting this, in first separating nature and people, and then bringing them together for commodity production. And that is where you get this whole thing. And therefore, we are now trapped in this language because this nature-culture divide has brought us to a point where the labor markets have gone completely crazy in the way in which they keep pushing down and down the labor costs and people can't live. And the environmental expropriation has brought us to an extinction point. Both these are part of the same problem. So we cannot look at nature problem without looking at the human problem, and we cannot look at the human problem without looking at the nature problem, if we accept that by humans we mean all humans, and by nature we mean all nature. So that is one kind of thing. So you can see that the nature-culture divide, or the nature comes and rights, which is my next concept that I will do, which are so integral and has become such a part of the way we think about these things. And what do rights do? Because rights are the ones that re-establish the relationship between nature and labor as contractual relations of some kind. Because everywhere, commodity production also needs labor and also needs nature. It's by bringing those two things together that we make goods and services and commodities and whatever. But rights turns each of these things by turning nature into property, by turning people into labor force, makes them subjects of contract. So you can now trade in both of those things. And the grammar of rights is the grammar of contracts, because you need two right-bearing parties to be able to buy and sell. You can't buy and sell if you don't have, rights to buy and sell. And that grammar then becomes the language of the whole commodity producing society. It has brought us to this crisis, but we are not able to escape that language of contract. We are not able to escape that language of contract because we are not able to escape the language of rights. Everything, let's give rivers rights, let's give mountains rights, let's give something rights. Well, rivers are not going to court because the very language of rights presupposes that there is a judicial, mechanism for things. And then, of course, who is going to then moderate that becomes an important question. And the third concept that I will, talking about language, focus on is this idea of corporations as persons. So Nike and Radha D'Souza are equal. It's a rather, one would think, a ridiculous concept, but we all live with it and we presuppose it in the things we do. So when an American court says, US court says, corporations have conscience, corporations have, human rights, we accept that. We accept that corporations are living beings, so we start talking about corporate social responsibility and forget that the capacity to make judgments, right or wrong, good or bad, is intrinsically human, that a corporation cannot make judgments. It's human beings who make judgments. And I'm reminded of Justin Welby, who is, of course, the conscience keeper of England, if you like, in his capacity as, Bishop of and somebody who heads the Church of England here. And he used to work for Shell, by the way, in his previous life. And he was once asked, do corporations have a soul? And one would have thought that, for the head of Church of England, this is a very fundamental question. And he said, yes. So you see how internalized this idea of corporations has become. But if you ask legal scholars, what is this legal personality about? They will tell you it's based on a legal fiction. And modern law is based on legal fictions. And lawyers will call it legal fiction. We call it in our practice as legal fiction. Yeah? I'll just stop by referring to the Intergenerational Climate Crimes Act. So what we did in this was produced our own statute. And it's available on the website. And the statute is written in a very formal legal language, just like your laws are written. And the way our statutes are written, you will have the opening line, which is the aims and objectives. This act is enacted on so-and-so date because in order to whatever is a public policy. Section 2 of the act, all statutes, pick up any statute. This is the structure of a statute, will have a section on definitions. In this law, people means this. In this law, a woman means this. In this law, so you can have a general meaning of whatever you like, but in this act, it means a certain thing. So everything has to have a very positivist definition to then become part of the law. So when we say, we need a law for this or that, then we need to start thinking about how is this going to be defined. And then statute law is totally decontextualized. There is no context to it, which is why this idea that whoever you are, whatever you are, justice will be done according to the way that some experts, because that's what judges are, interpret this law. And so you have sociologists, activists, people outside in the world who say, environment should mean this, nature should mean that, corporations are not people, etc., etc. All those kind of things, they get into a statute where they are given a fixed and a limited decontextualized meaning. And because that is the meaning that will apply in the court, outside the court, whatever else you may say, when you walk into the court, that's how it will be interpreted, as it is written in the statute. But we expect, because I have said nature should mean this, because I have said, rights should mean that, I don't accept the World Bank's definition of rights. I think this is what I would like to, define rights. We think that that is going to get translated in a courtroom setting in the way we want to do it, or we understand it. What the CICC does is flips it completely. So we have drafted a statute following exactly the same principles. What does climate, I can kind of just read an example, if you like. Humans, and I pick humans because people, the definition of people, has changed over centuries, in modern Europe, because people did not include Jews, people did not include working class people did not include, and now we are still doing that because effectively people does not include refugees, does not include asylum seekers. So this capacity to include and exclude is absolutely central to the way liberalism governs. And because this inclusion and exclusion is detached from any ontological, transcendental questions of who are we, why are we here, what's the meaning of life, questions like that. It allows infinite capacity to manipulate language in order to manage, if you like, through the medium of law. That's how it happens. So I'll just read the definition of humans. Humans means a concept-dependent herd animal that requires pre-existing concepts to negotiate the world around them and has capacities to make judgments and to review, reassess, modify, alter, change, and repudiate individual and collective behavior in a manner that may or may not be in the interests of future generations of humans and or non-humans. So you see, it's a very technical definition that follows that, but flips the meaning of what we understand as humans. Intergenerational includes all past, present, and future generations. For the purposes of this act, it is clarified that the term intergenerational is not limited to a single step in the line of descent from an ancestor, which is how we define it. The meaning of a generation is not limited to 30 years or any other definitive number of years. A generation may be of different length of time for different species. Intergenerational relationships includes relationships between humans, between non-humans, and between humans and non-human species. So we try to flip that. So what happened at the hearing, when you come into the court, this is the law that was applied. And so all the evidence that was presented, if you had just looked at the evidence, it could have been any campaign organization doing any of those things, because there was, for example, witnesses from India talking about mercury poisoning that Unilever dumped into their rivers. This kind of literature you have plenty in environmental movements. But I think what really changed that was the framing and the way that the law was then made central to the language as well as to the idea of justice, because that's where we want to get to. And if the concept of, and this is another thing with liberalism, we kind of assume that law is designed to produce justice. But liberalism never makes that claim. Never makes that claim. So where do you get this from? And I think this is something inherent, and I think it comes from within us, because every human being has a sense of right and wrong, fair, not fair. We know this. Justice, we can, discuss and debate whether in a certain context something is just or unjust. But the sense of justice, it comes from within us, and we assume that the courts are going to give us justice. So in the CICC hearings, we wanted to bring justice back center stage to the whole idea of law.